Time has expired. The gentlewoman from South Carolina, Ms. Mace, is recognized.
Thank you, Madam Chair, and I want to thank everyone for their time being here today. I am from South Carolina that recently implemented a fetal heartbeat bill that had exceptions for rape, incest, and life of the mother because I put them in there. It's one of the few states in the nation that has a fetal heartbeat bill with those exceptions because I told my story of being raped when we were first debating the issue just a few years ago. And I hope that the state of South Carolina, the legislature, and the governor keep those provisions in there, and also do not legislate whether women can go to other states or other locations if they so choose from the state of South Carolina. But in all honesty, I'm a constitutional conservative. I take the Constitution and my oath of office very, very seriously. And even Justice Ruth Bader Ginsburg talked about and discussed the concerns that she had from a constitutional perspective on Roe v. Wade for decades. Even Joe Biden 40-plus years ago was talking about overturning Roe v. Wade. There are a number of folks, and it was under President Obama when he had a supermajority in the House, the Senate, and had the White House, and said that they would codify Roe v. Wade and then chose not to because the left has used it as a fundraising juggernaut for decades rather than take the issue seriously. And now we have Supreme Court justices, we have protests and riots and folks that are showing up armed on the lawns of our Supreme Court justices. And whether you are left or right, it is the third branch of government, and we should not be encouraging these kinds of activities. The United States, and I don't want to forget, it's the states, not the courts, that are the true laboratories of democracy. And leaders at the federal, state, and local level are elected to represent the people in their states. And what Roe does isn't necessarily what the media has said or even some of my colleagues have said on the overturning of Roe v. Wade. It is not going to eliminate women's care for ectopic pregnancies, as I have heard. I had a miscarriage when I was first having my children. It is not going to eliminate health care for women who have ectopic pregnancies or who have miscarriages. And I don't know, of one state, if you can mention one state that's going to eliminate health care for women whose lives are endangered. One state. Does anybody have one state that's trying to say that we're not going to allow any health care for a woman whose life is endangered? Is there one state that's making that a law? Go for it, Ms. Shannon.
Yeah, I'd like to weigh in on that, and I'm just going to tell you what providers told me. When this issue came up in Georgia, providers told me that they were worried, even when you make an exception for the life of the pregnant person, that they would be
pregnant mother.
For the pregnant person,
female,
that they
woman, mother.
That they would be challenged as to when it's appropriate to make the decision to perform an abortion. And so this put fear in doctors. And I'll tell you this, you live in South Carolina, I don't know what your provider situation looks like, but we already have a shortage of specialists in Georgia. Over half of Georgia's counties do not have access to an OBGYN. We can't afford to lose doctors because they feel like they're going to be criminalized or sued civilly because they
Well, therein lies the debate. You bring up a great point.
That's
Therein lies the debate today is why so many women either don't have access to birth control, don't have access to medical care or health care, don't have access to understand if they want to keep their child, how to give it up for adoption. Why are so many women having abortions? Why they don't have access to care? And that's really what the debate, I feel, should be like. I would be remiss today if I didn't mention that some of our most important constitutional decisions have overruled other prior precedents because there's been some mention by folks across the aisle that the Supreme Court is not legitimate. But I want to mention a few here. In Brown versus Board of Education 347 U.S. 483 in 1954, the court repudiated the separate but equal doctrine, which had allowed states to maintain racially segregated schools and other facilities. By happenstance, earlier this week, I visited the federal courthouse in downtown Charleston, where in 1950 it was Thurgood Marshall who brought Briggs versus Elliott, arguing that school segregation in South Carolina was unconstitutional. This was the first case nationwide to challenge school segregation as a violation of the U.S. Constitution. That case would eventually become Brown versus Board. And the court has found then, as it's found now under Roe v. Wade, it was right and constitutional to overturn that particular precedent. I appreciate Madam Chair for the time today, and I yield back.
The gentlelady yields. The chair now recognizes